Greetings and welcome to Law and Life. This is an initiative by Senior Advocate of Supreme Court of India, Subodh Markandeji, to discuss on legal issues, statutes, and help us to understand court reasoning behind any judgment. Today we will be discussing on Quo Warranto. Sir, why we are discussing on Quo Warranto again? We did that in episode number 55 just last week. Is the question that viewers will ask us.
That's a good question. There was a time when, for years, there would be no judgment on the writ of quo warranto. Now we have many. This year itself, we had the Supreme Court judgment in Gadhvi's case, Gadhvi, GK Gadhvi versus State of Gujarat early this year. Then, as recently as 11th of this month, we had another judgment in State of West Bengal versus Anindya Sundar Das. And now the present episode on Professor Dr. P.S. Srijit versus Dr. Rajshri M.S. just decided on 21st October 2022. But here the appellant had lost concurrently in his writ petition before the single judge of the Kerala High Court, in writ appeal before the division bench, and he filed a review petition which was also dismissed. So that is why there were two civil appeals, number 7634 and 7635 of 2002, one in the writ appeal and the other against the order in review.
Let's come to the case in the present episode, sir.
The appellant before the Supreme Court, Professor Dr. P.S. Srijit, filed uh, a writ petition under Article 226 of the Constitution seeking a writ of quo warranto, challenging the appointment of respondent number 1, Dr. M.S. Rajshri, as the Vice Chancellor of Dr. A.P.J. Abdul Kalam Technological University, Thiruvananthapuram, as void in ab initio. So it came up before a learned single judge. So in dismissing that writ petition, single judge relied on the Supreme Court judgment in Dr. Kalyani Mathivannan case that is reported in 2015 6 SCC 363. The single judge held that unless the University Grants Commission regulations are adopted by the state government, the state law will prevail. So in this case, the state law is Dr. APJ Abdul Kalam Technological University Act, enacted by Kerala legislature. So, and secondly, once the search committee is constituted under Section 13 of the University Act, the appointment cannot be assailed. So against this judgment, the appellant filed writ appeal number 514 of 2021. Now that writ appeal, in our South Indian high courts is like latest patent appeal in Bombay, Calcutta, Madras, and Delhi high courts, and maybe in Punjab and Haryana high court. And it is called special appeal in high courts of Allahabad and Uttarakhand. That appeal also was dismissed on 2/9/2021. So he filed review petition number 634 of 2021, which was also dismissed. So that's why, as I said, there were two civil appeals. The division bench held that the University Grants Commission regulations were adopted by the state government, but its amendment was not adopted. Therefore, they are not applicable. That's a very peculiar finding. And so it affirmed the other findings of the learned single judge. The review petition also was dismissed. So the appellant filed specially petition, in which notice was issued, and it was disposed of at the stage of admission itself. In the Supreme Court, the appellant made these arguments. He said that judgment of the High Court is contrary to the law laid down by the Supreme Court in Gambhir Dan versus State of Gujarat 2011, 2021, 5 SCC 179. And then he also relied upon the State of West Bengal versus Anindya Sundar Das. That is so far not reported. Civil Appeal number 6706 of 2022, decided as uh, decided on 11th of October 2022, holding that the University Grants Commission regulations will prevail. Then he argued that state government had adopted the UGC regulations by its order dated 10th of December 2010, but the High Court held that the amendment dated 13/6/2013 was not adopted specifically. So that can't be a ground for not applying the UGC regulations. He further argued that search committee had to recommend a panel of 3 names for consideration of the chancellor, but it recommended only the name of respondent number 1. Uh, so he argued that the appointment was contrary to section 13(4) of the University Act. So let us see what the Supreme Court held. Supreme Court held that identical questions were decided in Gambhir Dhan G. Gadvi's case and Kalyani Mathivandan's case, namely that the appointment of Vice Chancellor must be as per UGC regulations. In Gadvi's case, it has been held that the state law is, if the state law is not at par with the UGC regulations, then then until the state legislature brings them at par with UGC regulations, the UGC regulations will prevail. Why? Because in the case of any conflict between the UGC regulations and state law, the UGC regulations will prevail because of Article 254 of the Constitution. That is to say, whenever there is a conflict between the union law and the state law, then Article 254 says that this union law will prevail. The Supreme Court further held that even in Dr. Kalyani's case, in para 53, it has been held that to the extent of conflict, the UGC regulations will prevail. And moreover, in Dr. Kalyani's case, the UGC regulations were silent on the applicability of UGC regulations to the post of Vice Chancellor. So as we have seen, all these 3 cases, are about the post of Vice Chancellor. And in Gadvi's case, which has been followed in Anindya Sundar Das case, the Supreme Court held the same thing, and recommending only 1 name, that is that of respondent number 1, was contrary to section 13(4) of the University Act, as also the UGC regulations. So both the judgments of the single judge and the division bench, as well as the order in review, were set aside, and a writ of quo warranto was issued uh, directing the Vice Chancellor, the incumbent Vice Chancellor, that is respondent number 1, to vacate the post of Vice Chancellor. So that's the